everyone, and welcome to part 2 of our two-part series on risk analysis and early mediation. This programming is a collaborative effort between the American Bar Association, TIPS Section, ADR Committee, and the Early Dispute Resolution Committee of the American Bar Association's Dispute Resolution Section. We're hosting this series to promote awareness of the ABA's recent adoption of Resolution 500, urging the increased informed and voluntary use of early dispute resolution. Part 1 of this series covered early case evaluation and risk assessments, and Part 2 focuses on effectively mediating a case early. I'm Ellie Vilendrer, and together with Felicia Harris-Haas, we're the co-chairs of the ABA's Early Dispute Resolution Committee of the Dispute Resolution Section. We're both arbitrators and mediators, and we're both the moderators for today's program. I'll hand it over to Felicia now to introduce the panelists.
Thank you, Ellie, and good day to all of our audience members and to our esteemed panelists. Thank you all for joining us. We have with us a panel of tremendous experience, both on and off the bench, in and outside of the mediation conference room. I'm just going to go through their names alphabetically because that's the only fair way I can think about doing it. So the Honorable Halim Dhanidina, he is retired from the court system in California. He has more than 25 years of legal experience, and about 9 of those on the bench, both as a California 2nd District Court of Appeals Justice and as a Los Angeles County Superior Court Judge. Judge Dhanidina got his start in law at the Los Angeles County District Attorney's Office, and now also shares his wonderful and vast experience teaching at the University of California, Los Angeles, the University of California, Irvine, and Chapman University Law Schools. And notably for Justice Dhanidina, he is recognized as one of 5 alumni judges selected for the University of California, Los Angeles Law School's 70 trailblazing alumni, commemorating the 70th anniversary of the school in 2019. Welcome, Judge Dhanidina. Next, we have Judge Andrew Edison. Judge Andrew Edison is a United States Magistrate Judge for the 2nd District of Texas and has held this position since 2018. His undergrad is from Dartmouth College and his law degree from University of Virginia School of Law. Prior to joining the ranks of the bench, Judge Edison was and still is a respected trial lawyer, appearing in front of state courts, federal courts, and arbitration panels, though not now in his role as judge, and successfully representing clients. He is also an adjunct law professor teaching remedies, evidence, and trial advocacy. And in his spare time, he likes to run marathons, although he says not very fast. And then last but certainly not least, we have one of the pioneers in Texas, someone I've held in high regard for since I was a baby lawyer, Eric Galton. Eric is the co-founder of the Lakeside Mediation Center in Austin. He is a Texas mediator credentialed, distinguished credentialed mediator, past president of the International Academy of Mediators, and he is a Texas super lawyer in ADR. He's listed among who's who of international commercial mediators. He's on the National Academy of Distinguished Neutrals panel. He mediates cases ranging from 2 to 125 parties and has a book that he co-authored with Leela Love, published by the ABA, Stories Mediators Tell. Thank you all for joining us. And Ellie, I'll turn it back over to you to kickstart the Q&A session.
Thank you so much, Felicia. So just to mention briefly before we start, to the audience members, please engage with us through the chat function. Questions, comments, we'll try to get to your questions in real time, but hope to make this an engaging conversation. So to start out, let's talk about how you can tell whether engaging in early mediation is appropriate for your case. Judge Edison, what factors should attorneys consider when determining whether to pursue early mediation? And are there specific case types or attributes that make certain kinds of cases better suited for early mediation?
Well, to start off, let me say, I think, early mediation obviously allows the parties to talk and try to resolve their dispute without expending a lot of time, effort, and money on the litigation process. I don't necessarily, and people might disagree with me, I don't think there is necessarily one type of case that is or limited to one type of case that is well suited for early mediation. What I think the parties need is to have enough information in their possession or the ability to get to make an accurate assessment of sort of the risks and rewards of proceeding. And I actually put a lot of the onus on the lawyers. I think there is generally a lot of reluctance on behalf of lawyers to candidly put their client's interest ahead of their own interest. And I think that early mediation really can allow the parties to get to the nut of the issue quickly, efficiently, and try to resolve their disputes without expending a ton of attorney's fees. And just as an aside, I was reading a recent book. Basketball star Rex Chapman wrote a recent tell-all biography, and in it he talks about a divorce case where he had and how he goes through and how they spend enormous time, effort, money, years. And he says, I wish we'd had an early mediation. And it sort of struck with me that, hey, no matter whether it's a simple, complex case, if the lawyers are willing to get involved, are willing to exchange information that you need to have that information to make those decisions, I really think it can benefit the parties, because a lot of times you just churn your wheels unnecessarily when it's actually in the client's best interest to at least make an effort at an early stage in the case to see if there's some sort of common ground that can be reached.
Thank you so much. Well, let's assume then that the attorneys have made that decision that they're going to go forward with an early mediation. Eric, you're super experienced in mediating. What should attorneys do to prepare to ensure that they're maximizing the opportunity for an effective early mediation? And what can a mediator do to help the parties get ready?
Sure. First of all, in terms of is early mediation being used today, the good news is it is. Since March of 2020, when we had to shut down our offices for COVID and begin to virtually mediate cases, and now we've returned to a mixture of both virtual and in person, early mediation was being used increasingly more than it ever had been before. And we can talk about later why that is. But in terms of the preparation, my first piece of advice is learn that the most important part of this phone is not the text button, it's not the email button, it's the actual telephone where you can actually speak to a human being. Preparation is the key to success in almost everything. That certainly goes for early mediation as well. So if you look at it from the vantage point of the lawyers first, and then we'll talk about the mediator. It's like Judge Edison just said. What do the parties actually need? What do they need to collect in order to have an effective mediation that is done at an early stage? And that requires communication. And it requires verbal communication, either Zoom your opposing counsel or telephone your opposing counsel. And it's about a 20 to 30 minute conversation, maybe a little less than that. But it's basically, okay, we're going to mediate the case of X versus Y. What documents do you need? What do we need to do so that each of us can properly evaluate our case and properly advise our clients? What I've noticed, and again, this is encouraging news, is that in the early mediations that I conduct, be they in employment cases, personal injury cases, the lawyers have really developed a pretty good habit of exchanging information voluntarily outside of formal discovery in the interest of having a successful early mediation. So that's really the essential piece an answer to your question. Now, what the mediators have to do is to remind the lawyers to do that. And so most effective mediators that I know will reach out to counsel before the early mediation and have a very brief pre-mediation conference call. I do it in virtually all of my cases. I call it the sort of 10 or 15 minutes heads up call, which is, we have a case that's coming up for mediation in 2 weeks. Do you have everything you need in order to proceed? Is there anything that you don't have that you need that I can help you get? And basically what I'm doing is channeling the lawyers to really get involved in this information share so that when we get together, no one's going to say, I've never seen that before. So, for example, and using a personal injury case as an example, although most of my work these days is in employment, but I do a lot of PI as well. If you really expect an insurance company to evaluate your claim for future medical treatment, you better have a letter that from a physician that says, in reasonable medical necessity, this is what needs to be done to this patient, and this is what it's going to cost. If you lay that out at the mediation session itself, it will never be evaluated. There's no way it can be evaluated on the spot. So if early mediation is going to be successful, you really got to get your ducks lined up. You got to get your data out there, and you really got to get the mediator involved. Most mediators are really proactive about that.
So you're saying you really want to get the information, not just for yourself so that you're educated, but you want to get the appropriate information to the other side sufficiently in advance so they have enough time to be prepared when they show up.
That would be exactly right. And let me just say it again in response to that. I'd reach out, if I were a plaintiff's personal injury lawyer, to the defense counsel and say, tell me exactly what you need, when you need it, and how long before the session you need it, so that I can give you all the tools you need in order to have your client ready and properly evaluate the claim. Yes.
Thank you so much, Eric. To tie this into the program we put on 3 weeks ago, because this is really one cohesive program. So part 1 of our series, the panelists talked about evaluating claims by defining potential exposure and gathering enough, but not perfect information to do that. Justice Dhanidina, building on the observations from part 1, can you talk about the role that early case assessments and risk analysis play in early mediation?
Yeah, absolutely. And this is all, it all really ties together. Most settlement discussions, if not all, are driven by this sort of risk analysis that each side is going to engage in. What do I have to lose by moving forward? What do I have to lose by compromising too much to resolve the claim early? In addition to these factual issues that have already been discussed by my other panelists here, are some of the legal issues too. You may have a situation where you believe that there is some legal reason why, let's say if you're on the defense side, you might be able to gut the claims against your client. And you don't want to move ahead with a settlement of those claims that doesn't take that into consideration. And so I think a really important thing that I'm seeing now in my mediations here with signature resolution is the attorneys are really interested in fleshing that out. And so they ask that of the mediator for some help there too. When I get a mediation brief in a case that's coming up, usually they will highlight any potential legal claims or legal motions that they expect to be filed. And I'll use sort of my background being from the bench or especially on the appellate bench to help them evaluate, this is kind of where I see this thing going. Oftentimes it's going to be in a court where I actually know the judges and have an idea by reputation of sort of where they look at some of the issues that might be raised, not only at the trial court, but then also on the Court of Appeal. And I think that additional education does help in the risk analysis component so that attorneys can advise their clients a little bit with more savvy going into a settlement discussion.
How about you, Eric? Do you talk about risk analysis in your mediations?
I think we talk about it, but certainly not initially. I'm not afraid to engage in a risk analysis conversation with counsel, usually in the separate caucus not in a private, not in a group meeting. There's been this debate for a long time about facilitative evaluative. How far is a mediator going to go? I think effective mediators employ a variety of styles, and sometimes they're a little more facilitative, sometimes they're a little more evaluative. On the other hand, if you've been practicing law for 48 years, like I have, and you've looked at literally thousands of both employment, personal injury, and commercial cases, you usually have a fairly acute idea of what cases resolve for and on what basis, and whether or not the case has wings to it, or whether it's a case that's operating just on thin air at this point in time and might be disposed of with a dispositive motion. So I suspect that there are always those conversations. One of my questions to lawyers, because lawyers are very proud of what's good about their cases, and I also have understood that asking a lawyer what their weaknesses is the wrong question to ask. But what I frequently will ask is, I tried cases for a living before I became a mediator. And there wasn't a case I had, good, bad, or indifferent, where I didn't worry about something. What worries you about your case? What keeps you up at night? What do you wake up worrying about? And how does that impact the evaluation of the case? Those conversations usually go pretty well.
Yeah, great point. Well, and also just to note, I mean, before you even get to the risk analysis part, as we were just talking about, you have to be sufficiently prepared. And there's two issues. One is the information you have access to on your side. And the other one, which you hit on very well, Eric, is what information do you need from the other side? But really, all the facts in a case are historical, right? So you can interview the witnesses of your own side. There's a lot you can do to come up with a pretty good risk analysis. So moving on that same theme, Judge Edison, as part of this preparation for mediation, how do parties reasonably predict an expected range of outcomes at trial? And how should they deal with the likelihood that the opposing party will take a different view?
Well, that's a great question, because there's no crystal ball that you can look at and for certain say, oh, here's the result of the case. But I think part of it, as Eric mentioned, the more experience someone has in a particular forum, a particular type of case, you get a feeling over time on what's going to happen. I mediate a lot of cases, although I'm not in the weeds in all of them. Usually, after I sort of read the general pleadings and talk to the parties, I can get a pretty good assessment of what I think is going to happen based on my experience, both in my years as a trial lawyer and on the bench. And I think it is imperative for the lawyers that are mediating to make that honest assessment. And I got to emphasize, to me, there's two separate aspects, right? One is the advocacy part, where you're going to vouch for your client and take the perspective, try to convince the other side or the mediator. But at the same time, you got to have that honest assessment where you weigh the strengths and weaknesses of your case, and hey, this isn't going to be a slam dunk, or there are these risks out there. And I'm always thinking, and it's always amazing in mediations to me, how many times people come in and they're just sort of hell-bent on, we're going to win, we're going to win, we're going to win. And I'm always want to step back and say, okay, that's the advocate in you, but you got to look inside and assess, what are the real risks? What are the rewards? Because there's that old saying that if you ever talk to a trial lawyer, any trial lawyer that says they've never lost a case has never tried a case. And there are risks, no matter how good your case is or how bad your case is. And look, what is it? 99% of all cases settle. Most cases settle because at the end of the day, I think a lot of times, we're at least close on what the people think the risks are, that maybe they're willing to move. To me, those cases that don't settle are really the ones where someone's just way off on the risk assessment. And so I think it's imperative to make that risk assessment, and especially for early mediations, as has already been said by my other panelists, you got to have the information, and it really requires the parties to work together, right? I don't need to take 50 depositions, but if you got key documents you need or want or information, get those, exchange it. And it is imperative, as Eric just said, if example, plaintiff personal injury case, if you got a bunch of medical bills, show them to the other side, send them. If you're trying to recover $1 million in damages, don't wait and sort of hide them and say, oh, by the way, I got a bunch of, here it is, right? You want to make sure that there is that exchange, not only to help convince the other side, but really to set forth as to why you think you're entitled to whatever it may be.
And of course, there's always speculation in these numbers, right? It takes some educated guesswork, but do you think it's important to actually support those numbers with specifics? For example, I think my case is worth name a number, and I'm going to back that up with more intricate calculations. For example, I think I have a 25% likelihood of defense verdict, or 30% likelihood of getting a certain outcome. So do you think it's important to really break that down more nuanced to really understand the calculations that are going into your expected outcome at trial?
Well, I think that question is going to get a lot of different answers, probably 3 different answers from our panelists. My personal view is I would never, as a lawyer, I'd never tell the other side, hey, I'm giving you a 25%. But I think internally you got to make that determination or calculation. But I'm not sure I'd really, say, okay, I agree. There's a 50% chance I'll win or lose. On one hand, you want to take that, that strength position, but at the same time, realize, at least internally realize where your weaknesses are or how you can accommodate to really advance your client's interest, whether it's resolving the case, avoiding attorney's fees, getting the case resolved and moving on, whatever it may be, in my view.
You got to be realistic with your side, at least.
With your own client, especially.
There are always those private conversations that we have with our clients as advocates that we wouldn't necessarily have outside of a private conversation with those advocates. But in mediation, the conversation often turns between the difference between settlement value and trial value. And there is obviously a candor that comes in the mediation process that is subject to confidentiality, and the duty, obviously, to, under the new rules, the Texas civil procedure and other federal rules, to provide information early in a case that you're going to rely on at trial anyway. So that information exchange, I'll just add my little 2 cents here before I ask the first question. That is there really is no benefit to not turning over the information, because if you end up in court or on that path to court, you're going to have to turn it over anyways. But I want to switch gears just a little bit. Ellie did a great job laying the foundation for this next question, which I'm going to ask Eric, as the most senior of our mediators on the panel, to weigh in on. And let's talk about what it looks like. What is this? Can you share with us an example of a successful early mediation? Like what were some of the strategies that you saw or techniques that you used that worked to help the parties resolve a case early, a complicated case early?
Yeah, I can give you an example. I was on the phone with 2 commercial lawyers who were excellent. And the case they had were 2 friends who both had worked for the Department of Defense, one of whom left the Department of Defense and started his own business, working as a defense contractor. His friend stayed at the Department of Defense for a while, but then at a certain point decided to join his friend and become a partner with him in that business. Ultimately, there was going to be a business breakup and a long-term friendship between people who had known each other forever, gone to each other's weddings, had dinners at each other's house. The social interaction had stopped completely. Friends hadn't talked for 1.5 years, and the lawyers had gotten with their clients and told their clients just how much it would cost if this business dispute was litigated. I'm going to tell you in a second what it was really all about. So we agreed that we needed to have an early mediation because there were both business expense and social interaction and relationship issues involved. And I asked the lawyers what needed to happen at this early mediation for us to be successful. And they gave me one of the most surprising and wonderful answers. They said, we need more client talk, not lawyer talk. Well, the reason for that was that when the second person decided to join his friend as a partner, and before they began to work together, he said to his partner, you know what? I guess we need to write up our agreement and how it's all going to work out. I've got a lawyer. I guess we need to get a lawyer to write up documents. And his partner or future partner said to him, okay, I guess if that's what you want to do. And they wound up having a lawyer write up an agreement that included that in the event of dissolution, what each guy would get and what had to happen for them to get that money. Well, they then had 8 successful years of business until one day, the junior guy who joined his friend said, you know what? You wanted to start your own business. Now I want to start my own business. And so it all looked pretty good. And they all looked like they were going to part as friends. And this guy was working on a project that would have given him a $3.5 million commission. So as he's almost out the door, he says to his now former partner, but still friend, and by the way, I'm looking forward to getting that $3.5 million commission check. We all made out really well on it until his partner said, I'm not paying it to you. So this is what the fuss was about. At the early mediation, the two gentlemen, their lawyers stood to the side, wouldn't even look at each other. They wouldn't say anything to each other. So I got them in a private room, and because of the constructive participation in an early mediation, I asked the guy who founded the first business, why are you so unhappy with your friend? You had a very successful relationship. You guys were best friends. What on earth happened to the point where you didn't want to pay him this commission? And the reason he didn't want to pay him the commission was the written agreement that I mentioned earlier said that he had to be employed and physically at the business when that commission came in. And it turned out it came in 9 days after he left the business. Why are you holding his feet to the fire? And you'll never guess what the answer was. I never, ever forgave my friend for making a lawyer write us up. What did he think I was going to do? Did he think I was going to steal from him? And I looked at the gentleman and I said, have you ever communicated to your partner that you were unhappy? He asked a lawyer to write an agreement. And he looked at me surprising and he said, no. I never told him that. Why would I tell him that? I said, would you tell him that today? He said, well, I guess I will. I put the guys together. And once he told his friend, that's where all of this negative energy came from. His friend apologized, said he had no idea. His friend thought this was aggressive. He missed seeing him. They started talking to each other. And the next thing that happens is they kicked me out of the room because they wanted to have a private meeting. An hour later, when I walked in, one of them looked at me and said, you know, Eric, we're friends now, but we can't work out the case. I guess they wanted to press my button. And then one of them laughed. He said, we've got this all worked out. Bring in the lawyers. We want to tell you what our deal was. And early mediation prevented those guys from going, according to their lawyers, through about 3.5 years of litigation, never having any ability to resurrect their relationship, and probably saved each of them pretty close to $500,000 each in legal fees. That's what early mediation can do if you handle it the correct way and the lawyers cooperate.
And let me chime in on there because that's an excellent story. And I had one recently, which was a very large commercial dispute. And the parties asked me to mediate. Case gets referred over to me, and I look at the docket, and I basically got a complaint, and that's it. I mean, there's I think maybe an answer or maybe a motion to extend time to answer. And I talked to the lawyers, both sides very good. And this is where I really got to say, I think the onus is on the lawyers a lot of time. And I said, what's going on? Well, why are you mediating? So, what's the deal? And they said, hey, we really want to assess the strengths and weaknesses. We both realize we need some information. We each want to take one deposition and get some information, but we've agreed we're going to do that up front. And then before we spend a bunch of time on motion dismiss, repleading, all this stuff, we want to get together and mediate. And the result was, we ended up resolving the case, and I really applaud the lawyers for doing it, because it was, hey, let's exchange what we need. And like, as we've talked about, you got to have that informational, the wealth of information. But once we had that, we don't need to take 47 depositions and get into the weeds. We at least understand the general parameters, and we understand, generally speaking, the risks, the rewards, and really not only the legal fees that would be spent, but just the time, effort of the parties, sort of avoiding, spending it away from their business and trying to make money. And that's why I think it's so important for the lawyers to be actively involved and to work together, has been said, because it was a pleasure to be able to get into that situation where you could disagree and you wanted to, but it wasn't done in a way that, hey, we're not going to resolve it. Let's try to figure out, is there a way? If there isn't, that's what our justice system is for. Let's roll the dice and we'll go forward. But hey, let's give it our good old college try to see if there is a resolution and if the parties can sort of assess the risk in a somewhat comparable way.
Very, very good. Judge Dhanidina, would you like to also share some information on this topic?
Yeah, I mean, I think there's an added wrinkle here too that we've all kind of been touching on, and I actually see that it fortuitously just popped up in the chat too, which is, the nature of the attorney-client relationship here is a very sensitive thing. And, when someone hires their attorney in anticipation of a lawsuit, they want someone to go to war. They're hiring someone who will, basically use everything in their toolkit to prevail and to beat the other side down. And a lot of times in that initial conversation of trying to decide which lawyer to engage, clients are drawn to lawyers, frankly, who will tell them, you've got a great case, we're going to win this, and we're going to destroy the other side, and there's something really great that's going to come out of this at the end. Now, that being the nature of that relationship, and more often than not, it's very, very hard for the attorney then to say, you know what, by the way, I know we've just barely gotten started here. I'm not seeing this thing ending up good. We got to take what we can and get out of here, right? You're going to be talking out of both sides of your mouth at that point. And the client's not trying to hear that, at least not from you as the lawyer. The mediator, I think, has a role to play in sort of being that neutral party with, certain degree of experience, who can be that other voice in the room and say, you know what, you've got great counsel here. You've chosen an amazing lawyer. Many good things can come of this if you take it all the way. But let me also make you aware of some of the downside. And this is sort of part of that risk analysis. I think the mediator can play that role in sharing some of those risks in a candid sort of way that the attorney might have a hard time doing. And I think it's really important too, if you are the attorney and you have this pre-mediation conference with your mediator, to be as candid as you can. Cases do not settle because one side decides they have a bad case and they give up, right? The cases don't settle out of capitulation, certainly not at the beginning. At the beginning, everyone's very optimistic. And, it's important for, I think, the attorneys to communicate with the mediators, hey, these are the things, like Eric was saying, these are things that worry me. I'm going to have a really hard time getting the client to hear it. And that could be in the context of all of the previous conversations they've had. And so I think, you want to use the mediator, you're hiring them, use them as a tool to say the things that you can't and to share the information that maybe you feel less comfortable sharing.
We have a question in the chat. I want to get to this because we said we'd make an effort to get to them in real time. Well, we have a couple questions. One of them, Justice Dhanidina, I know you were planning on covering, so I'll hold that one off for when you get to it. That was about how you get through to the clients that early mediation is not a sign of weakness. But I'd like to get to the other question right now, which is, what suggestions do you have when you realize that opposing counsel have their own personal dispute unrelated to the underlying case in addition to the parties? Any helpful tricks?
Any one of you can answer that one.
Well, let me just take a quick stab at it. That 10 minutes heads up before the mediation session, usually 2 to 3 weeks out call, is designed to sort of get that sort of stuff on the table. It's not a granular conversation. My heads up call is, listen, I need to know, I need to get a view of this from 10,000 feet. And where are the landmines? What could really explode? One of the things that has exploded when I've asked that question is opposing counsel and I are the problem. We're the problem. We don't get along. Now, look, I've taught a course on civility for the past 7 years. And I think the good news there is, for the most part, lawyers engage with their counterparts in a civil manner. However, if you practice law long enough, or if you're on the bench long enough, you know that inevitably you're going to encounter somebody with whom you do not have a interpersonal relationship that's very good. So when that's on the table for the mediator can be what I call a process architect and say, okay, let's acknowledge that. How can we construct the mediation in a manner that puts that off to the side and allows the dynamic at the mediation to be constructive and positive? One of the ways that might happen is we're not going to have a general session. We're not going to have lawyers who are in a pedantic and theatrical way going to put on a performance for their clients. And what we're going to do is we're going to go immediately into the private caucus, and we're going to let the mediator do his or her job with the parties and begin to do things with the parties. One thing I want to say about early mediation is, and I don't know what the judges' experience have been with this, I think it's actually tougher to settle a case that's 2 weeks outside a trial where the parties have been at it for 3.5 years than a case in which the parties are at the very beginning of the case. They're beginning to think about how this is all going to go, and all of that is in front of them. You know, we live in a society where now is what matters. Today is what matters. You know, the virtual world has accelerated things. Imagine what's going to happen in a year when AI is on everybody's laptops and everything is accelerated even more. And so one of the things that mediators sell at an early mediation is the now. And the now for a business is not so much what is it going to cost you to defend yourself, which is a really bad question for a mediator to ever ask, but how many resources are you going to have to take away from your business to deal with and manage this litigation, and what opportunities are going to be lost? And you know, when you really go back to the whole underlying thought of the ADR movement, and my dear friend Judge Evans, who got me into it in the 80s, part of it was to allow access to parties and to unclog the courts and give people the ability to resolve their disputes in real time, not 4 years later when the issue may actually become almost academic. And so, you know, when you talk about what are you selling at early mediation, you're selling an efficient resolution, saving time and quality of life issues, which are important to human beings.
Let me add to that. You know, what you're also selling is a measure of control. There was a question in the chat earlier about, you know, how do you convey to a client that a settlement is not a sign of weakness? And, you know, in my earlier comments, you know, sometimes you want to talk to the client about what a weakness might be in the case, but really what you want to talk about are two really important things. The first one is, you know, some of the reason why you're settling is not because you're weak. It's because you want to have a larger measure of control over the result. Like, you know, you may have a really strong case factually and legally and still lose, right? You know, this is the way our system works. Our system works so that other people make the decision of what happens to you. And I mean, how many people can live with that? You know, if we were to, you wouldn't go out into the middle of the street and ask 12 random people, hey, where do you think I should have dinner tonight? You're not going to give them that decision, but you're going to give them the decision over something existential for your livelihood or for your company. Why would you do that if you can have some control over it yourself? There's value in finality. You know, everyone talks about, and appropriately so, the risk associated and the cost associated with losing, right? But we don't spend enough time talking about the cost associated with winning. There is a cost associated to all of that. You know, you may be, let's say you're going to get into a fist fight, and because you're in the right morally, and you have the good fortune of being stronger than your opponent, and you're going to win that fist fight. You absolutely will win at the end of the day. Will you have a broken hand? Will you still have all of your teeth? Are you going to be scuffed up yourself? Of course you will. There are costs associated with winning. And some of those costs have to do with what Eric was just saying in the delay. Do you really want to spend the next 3 or 4 years consuming your resources and your energy and your emotions on this case if you don't have to? Maybe you win, you go to the Court of Appeal, and guess what? The Court of Appeal decides, the thing that the jury said you get, you don't really get that. In fact, you get much less. Maybe you get nothing, and you have to do it all over again. There's costs associated with all of that. And I think good mediators spend a lot of time conveying that to the client so the client understands, look, I'm not settling because I have the wrong lawyer or I am not right morally, factually, legally, but there are other imperatives and reasons why it makes sense for me to settle the case now and compromise.
And let me offer one other suggestion, because I think it's a valid question, right? You know, how am I going to convince my client, you know, they want me to be the hard charging trial lawyer. How am I going to convince them that, you know, it's not a sign of weakness to go to mediation early? Look, the reality is in our judicial system now, more and more judges are requiring that you mediate before you go to trial. Sometimes, I mean, some judges more than once before you go to trial. And if I'm a lawyer, it seems to me I can go to my client and say, look, we're going to have to mediate. Okay. Why don't we go now? Right. We might not resolve it, but why do you really want to spend all this time out of your job? Do you want to spend all these attorney's fees if we're just going to be back in the same position we are 9 months, a year, 18 months from now? Let's give it a shot now. Let's exchange what information. If they're crazy, if they're not seeing it the same way, that's one thing. But let's at least make that effort now, really in an effort to save you, us, everyone, a lot of hassle down the line. And I think if you convey it that way, your client doesn't view as, oh, he doesn't believe in me or she doesn't believe in me or doesn't want to take the case, but rather, boy, I got a lawyer who actually is concerned about me and is actually looking out for my best interest. And I think that can be very helpful in many respects.
Yeah, sorry, Ellie, I just want to pick up on that point because Judge Edison made a point that, Ellie, you know, and we've talked about a lot, and that is the value of having these candid conversations with our clients before they expend a lot of time and energy in the litigation process actually can enhance the relationship between an attorney and a client and referrals later, because the clients are going to speak well of the lawyer for helping them get out of a problem that could have otherwise done a lot of had a lot of ancillary tentacles in other areas of their business, et cetera. But I also want to just real quickly, and Ellie, I want you to do your comment, but real quickly, y'all haven't mentioned, but I think it would be helpful to sort of bring into this one concept, and it's this: the courts are limited in what they can do. Even if you go through the court system, whether it's through motion practice or through a trial, the resolutions, there's really just two options that judges have, right? Judge Dhanidina and Judge Edison, you're going to pick a winner, you're going to pick a loser. Someone's going to win that motion, someone's going to lose it. Someone's going to win that trial, someone is going to lose it. When the parties take control, to Judge Dhanidina's point, they not only have the ability to make those decisions about how they want this conflict to end, but they also have a tremendous amount of dexterity in what their options are for resolution. And Eric really highlighted this for us in his wonderful example, and that is the resolution those clients came up with, a court could never in a million years give them. It's just not an option a judge has. So the ability to have this conversation with your client and tell them, look, if you need me to go to the mat, if we need to go to the mat because it's the best interest of your business, yes, we can do that. But let's take a step back and see if maybe there might be some things that you can get out of a resolution that you control that a judge could never consider, that's even a better outcome for you because of the creative process and the open lines of communication, and not to mention, but to highlight the confidentiality of the entire process. So Ellie, I'm sorry, you were going to say something.
No, I was just going to bring up Professor John Landy's question from the chat, which goes in line very well with all of this that we've been discussing. He says, How much should attorneys and mediators consider parties' intangible interests, such as stress of continued litigation, risk tolerance, concern about relationships and reputation, opportunity costs, internal organizational conflict, among many others? And when should these intangible interests be raised? Should mediators wait until the end of the mediation and discuss these interests only as a way to close the gap?
Let me respond. And hello, John Landy. It's good to hear you're out there. We've known each other for quite some time, and what a remarkable voice for mediation he is. Actually, these, and I'm pretty sure it wouldn't surprise John, these are front-end conversations with me. And I'll give you an illustration. It's always good to provide one. But I had a husband and wife who had a real estate dispute. Actually, it was a homeowner's dispute, and many of you know how incredibly terrible those can actually get. And they were both very, very committed to what their position was, and they had been at it in the litigation for about 6 months. So not that far along. There was a much longer path in front of them. And I walked into the room, and after I said hello to them and we got to talk just a little bit, I asked them a question that I now ask almost everyone who's involved in one of the cases. And I looked at the husband and wife and I said, "How often do you two talk about this case?" And you should have seen the body language. The husband's shoulders slumped, the wife put her head down. And she said, one of them looked up and said, "All the time." And I said, "How is this impacting your relationship?" And the husband looks at me and says, "We go out to dinner, we're having a nice dinner, we're drinking a glass of nice wine, and somebody brings up the case. And all of a sudden the vibe's gone. We can't go a day without talking about a case. And then when we get a email from our lawyers, we hold our breath and we read the email, and it basically occupies all of our energy." Well, how is it going to feel if we carry this forward another 3 years? Can you imagine if we work hard and diligently today? You could walk out of these doors today and take your lovely wife out to a restaurant, and you can have that glass of wine and not talk about that case. How would that feel? And they don't even need to answer the question, because they're already visualizing the possibility that their humanity could be restored to them. None of this, by the way, is anti-litigation, anti-lawyer. One of the other things that early mediation can do, when despite the best efforts of the parties, their lawyers, and the mediator, that don't resolve, and cases sometimes don't resolve, the overwhelming percentage do, is it ever at least gives them clarity that they made the effort to try to work it out early before they commit their resources and their personality and their well-being to litigation. And I think that's a feather in the cap of the litigators who are going to carry that forward, because they gave them that potential exit ramp.
And along those lines, I do think it's important for lawyers to try to help the mediator. And what I mean by that is, I had a case recently where, and I, like Eric, I have these pre-mediation calls. I want to understand the issues ahead of the mediation. And I said, what can I do to help? And the lawyer said, my client needs to resolve this case, but my client really wants, whether it's his day in court or the opportunity to vent, to talk. So, Judge, I need you just to listen to him. And I, great. And, I turned to him and I let him talk for 45 minutes. And it would really seem sort of, I don't want to say, therapeutic, but, at the end, we were able to get a resolution. I think part of it was he just wanted to feel as if he had really said his piece. And I really, once again, I congratulate the lawyer for recognizing that, realizing it, and reaching out to the mediator saying, "Hey, here's something that can help us try to sort of overcome it." So I encourage all the lawyers out there, use the mediators, not only to try to help, pass numbers back and forth, but really give them the tools that they need that you think are going to help, make progress on both sides.
Yeah, and I think that validation component is really, really key because, the people who are involved in litigation think that they're right. And oftentimes, like Eric was mentioning in an earlier example, there's a moral component that they believe that they are right and they have been wronged by somebody else. And in addition to wanting to just vent about what they're going through, they want someone to tell them, you know what, I think you're right. I think you are correct. You were wrong. These things should not have happened to you. But that is not enough of a reason to forego an early settlement if one is possible. I use an example sometimes of, if you're a store clerk and someone comes into your store and they put a gun in your face and they demand all the money in the register or they're going to kill you. You have a decision to make. Now, are you morally right in refusing to give any money over? Of course you are. That's your money. You shouldn't give it to someone just because they put a gun in your face. However, is that the decision you're going to make? Probably not, because being faced with those alternatives, you're going to pick the alternative that allows you to live another day. And sometimes we find ourselves in these difficult situations, not because of anything we did, but just because the circumstances are such that it forces us into making a difficult adult decision, even when we are right. And so sometimes, in addition to letting the client vent, I think it's important for the mediator to not just listen, but sometimes also just validate. Yeah, I see your point. This should not have happened to you. You are right. But that doesn't mean you should forego that settlement if it's achievable.
And I just want to highlight one thing that I think we all know, but just to put a finer point on it, we've been talking about, and it seems to suggest a lot of interpersonal relationships, but these conversations do apply in business decisions as well, because as we all know, when you're in front of a jury, you are humanizing your corporation, you are sharing the human element, and decisions within a company are made by humans. And it's important, I think, as a mediator to somehow bring those thoughts and issues to the surface, so we understand that the decision makers oftentimes can be the problem. They can also be the solution, especially if they have escalation of commitment and there may be some other issues going on. But I just want to highlight that because oftentimes I get, well, that's good for that kind of a case, but not for this. These are across the board great pieces of information. We do have a question I want to share with the panel. It comes from Sidney Kanazawa in California. He says, here it is. It's kind of long, but it's a great question. What are your thoughts on whether parties should include a mediator in settlement discussions before they attempt to negotiate, or whether they should try to negotiate without the mediator before asking a mediator to help? And then the second part is, are there concerns about getting the parties together after a failed negotiation, or is it better to allow that failure before going to a mediator?
Well, I could see, and hi, Sid, thanks for the question. Sid also is a great mediator out here in California. I could see advantages to both, really. I've had attorneys hire me to help them evaluate a case and try to decide, in that process, what should they be trying to settle a case for outside the scope of a mediation. Obviously, I always encourage attorneys, if they are willing, and clients, if they are willing, to try to settle their case even without the mediator. That's really the goal here, if you can do it. Unfortunately, a lot of the cases we get, and the cases that I get, are cases where there has been some attempt to settle the case outside of mediation, and it just didn't work out. It failed either because of timing or because of other reasons. And so I don't think that it's necessarily a disadvantage. A mediator can play a role both before a formal case settlement or negotiation occurs or after. I think we've all kind of discussed ways in which you can employ a mediator to your advantage. And I think it's great to also consider the possibility of using a mediator even before you go to a formal mediation.
Anybody else want to weigh in on that one? Judge Edison, Eric?
Well, I think that there are numerous occasions where I have been hired early and we've had a mediation session, but the goal is not to settle the case. Mm-hmm. The goal is to incorporate the mediator from the very infancy of the dispute to sort of assist in creating a sort of path forward. And that might include, how far along do we need to go before we have a mediation session? What could that mediation session look like? Again, this comes under my favorite new topic, process architecture, which is, I think, one of the things that has happened with mediation since it's become commercialized, back as opposed to back in the 80s, is that everyone thinks there's a one size fits all to mediation, and that one sort of approach works. And that we've got to put all our eggs in one basket into one mediation session. Who said it had to be that way? There are complex cases in which including a mediator in an early mediation to try to develop an organized path forward makes everything easier, including the ultimate session itself, which may be more successful. I think we need to be more artistic about this. I think we need to be more creative about it. I wish more lawyers who were going to have a mediation session would call me earlier and say, we want to deal you into this at the outset and help us sort of develop a plan together. It's not a bad idea.
Eric, I think you've touched on something that I've had a number of conversations with, even as late as this morning before the session. And that is that mediation in its earlier stages was thought of as an event. And now I think we all recognize it's a process, and it's a process that is one where we serve as neutrals, as a voice that can help them communicate confidentially in ways that are so meaningful to their client's analysis of the case that they wouldn't have otherwise. Because as we all know, and as the lawyers know, we're the one voice in the room that's heard the voices in the other rooms in a confidential way. And while we're not disclosing confidences, what we are doing is helping to communicate and open those lines of communication. What is one of the first rules we as advocates typically give our clients, especially in high dollar, high significant cases? Let's stop the lines of communication because we don't want anything said inadvertently to be used to hurt your chances of getting the case resolved later. Well, this is the way to keep those lines of communications open and not hurt the case later. So I just wanted to highlight that because it's such an important point, Eric, that you bring up. We're coming to the end of our hour, and there's so much wonderful information. I'm just checking to see if there are any more questions in the chat. I don't see any. So just as sort of a final question for the panel, each of you have your own experiences, but each of you are supremely and deeply involved in litigation and dispute resolution. What do you see? Give us a sense of the crystal ball. What do you see on the horizon as the emerging trend or the evolution of mediation and early dispute resolution?
Well, in 2 minutes or less, COVID had no good to be said about it, except it took reluctant mediators like me who thought you never could engage a party virtually as well as you could in person, and put us through a new process. And 2 years later, we're all doing things very, very differently. I think that one of the things that used to discourage early mediation was logistics and cost. Now we have the ability to create a mediation virtually without people having to travel. And there's been the advent of half-day mediations where parties aren't making a commitment to an entire day, but perhaps a morning or afternoon to just see whether or not mediation will allow them to reach progress. Sometimes they settle in 4 hours. Sometimes they realize there's 1 or 2 things they need to do, and then they return the mediation to finish the job. So I think the future of early mediation looks exceedingly bright. How AI will mess with our minds? Well, that's a chapter that we're all going to have to wait for, but not very long. It's almost here.
Agree.
And let me just chime in real quick. You know, it's funny when you think about it, 4 years ago, I didn't know what Zoom was. I'd never heard of Zoom. The thought that we would be people all over the country participating in mediations online was just a foreign concept. So, you know, I guess the only thing that's certain is that nothing is certain, and I guess only time will tell is sort of what the future holds.
Very much. Judge Dhanidina, would you like to say any parting words before we close up?
You know, nothing other than I think everyone is here for the right reason, and that is to recognize the fact that early settlement is more and more common, as Eric pointed out at the very beginning of this talk, and then there's very good reason. And I think as the courts continue to get more and more impacted and it gets harder and harder to achieve the types of results that you want through litigation, early mediation is only going to be more in demand.
All right. Well, a huge, big thank you to all of our panelists and to our audience for joining us this day for this presentation. This is, I want to remind everybody, this is a joint two-part series that is co-hosted by the ADR committee of the ABA TIPS and of the EDR committee for the ABA section of dispute resolution. Ellie and I want to thank all of you. This program is being recorded, so all of you who have registered, you will receive an email with a link so you can listen and share this information with your colleagues and friends. And for anyone interested in joining the ABA or one of our committees, Ellie and I would love to see you at a meeting coming up. Please reach out to Ellie or myself. Our information is available online. I put our email addresses in the chat at the beginning of the webinar. So we do look forward to hearing from all of you. And on behalf of all of us here today, good day. Thank you so much.